Hi, so good afternoon to one and all. I start today with the next chapter of the new syllabus, economic business laws and intellectual property rights. Today we will be doing patent law. Patent law I think we should cover in 2 to 3 lectures, but completely we will be covering. Now before I start, I need you all to confirm whether I'm audible and visible to you all or no. Okay, in the chat box if you can just put whether I'm audible and visible so we can quickly start. Okay, great. So I'll start with the next one, that is your patent law. Yeah, just need a confirmation from you all in the WhatsApp, in the group, in the particular chat box, whether I'm clearly audible and visible or no. And then we will start and finish it off. Just yes or no. Okay, so let's begin. Hi, so we'll be starting with the patent laws. Patent law is one of the most important intellectual property laws and one of the most flourishing as well, as in this day and age of digitalization, of artificial intelligence coming into play and innovation. Patent law becomes very important. Now let's understand what do you mean by the term patents. Okay. So patents is nothing but a right. Patent is a right given to an inventor, to a person who has invented a particular product or a process. Okay. So let's say if today I have invented a particular device which is capable of industrial use, which is which is going to be very useful to an industry, to people at large, I can go and patent it. We see so many, Shark Tank pitches, or we must have seen some kind of investor pitches where people come in, they say that we have invented this product, we have invented a particular product. The first question that the investor will ask, have you patented it? Patented simply means that have you got it registered in your name? If you have been, you have to go to the patent office, give them all the details of how you have patented it. Once you do that, you will get a certificate and your invention will be patented in your name. So once you patent it, you get a right, exclusive right to manufacture the goods, to use the goods, to sell the goods, to assign the goods, to rent it out, to earn royalty and commercially exploit on your creation. Now, patent is a statutory right, that is a right from the government. Okay, it's a legal right for a invention granted for a limited period. Now, when I say limited period means what? If I have invented a particular product, you think that the patent will forever be in my name and that the public and the other industry cannot ever use it for further creations? So the answer is no. You get a monopoly right. A creator will get a right in his name, but it will be for limited period, 20 years. After 20 years, it goes into public domain and public can now start exploring that particular invention. So for 20 years, the inventor can solely decide what he wants to do with the invention. Whether he wants to use it, he wants to manufacture it, he wants to license it to someone, it is his right. So patents, when you get it in your name, the monopoly is not forever. It is only for 20 years. Okay. And in exchange of full disclosure of the invention. So obviously you will get this monopoly right, this statutory right, only if you give complete disclosure of how did you invent a particular product or patents. Okay, let's see. Next is, and also you get a positive right. A positive right is a right to use it yourself, and a negative right also you get. A negative right is to exclude others from using it without your consent. So it is a monopoly right or a monopoly grant which enables the inventor to control the particular sale, production, manufacturing, licensing of your invention. Simple, obviously he has put a lot of efforts to invent it. Only then he will get this rights. Now let's look at the legislative history of patents in India. That means, which is the laws that govern patents in India today? If today I have invented a particular product and I want to register in my name, how do I do that? So we will see the entire laws and we will see the entire process of registering a patent in the name. And I will show you the practical side also, along with how the form filing is done, etc. In the later part of the lecture. First, the legislative history. Legislative history tells that the patent law in India, when did it come? So the history of the patent law starts from 1911, and when the Indian Patents and Designs Act 1911 was enacted. Now this was of 1911. Presently in India we have the Patents Act 1970 read with the rules which were in 2003, which governs the law relating to patents. Patents was enacted by the government. Patents Act 1970 was obviously enacted in 1970 in pursuant to the powers given in the Constitution of India in your list, in your Schedule 7, List 1, Entry 49. So when you go to your Schedule 7, Schedule 7 of the Constitution divides the powers of the central government, state government and certain powers which both can use. So this comes in List 1. That means this entire law is made by the central government. So patents is covered, governed, administered by the central government or the union government. Why? Because it is given in List 1. Whatever comes in List 2, state government will handle. So this is a central act. And in List 1 you go to entry number 49. It talks about the central government has the power to govern patents, inventions, designs, copyright, trademarks and merchandise marks. So obviously your entire IPR, intellectual property rights, is coming under the central government, and therefore these are all central acts, because of which there will be one act all over India. There is no specific state acts that are there. So good for us as lawyers, as company secretaries, once we know this law, this act which we will be doing today, you can practice anywhere in India. Now, the patents offices are headquartered in Calcutta and has branches in Delhi, Chennai, Mumbai. So when we go here, where all are the offices? So these are all the offices of the intellectual property rights offices. We are concerned with the patent office. Okay, we are doing now the patent office. So the head office is in Kolkata, and then the other offices are in Delhi, Chennai and Mumbai. Now let's understand, I think you must have got a brief idea of what is a patent. Okay, so let's see. Patent is a right or a legal statutory right or a legal certificate. It is a certificate that gives you right to protect your invention. So you can protect your invention from being copied, from being used, from being sold, from being manufactured. Complete right is given to the patent holder called as the inventor. Now when we say it is given to protect your invention, so we have to understand what is an invention, right? See, only inventions can be patented. So patent is a right given to a person who has invented something. Now what do you mean by the term invention? So they have defined it. Okay, so let's see. Invention simply means, a new product or process involving an inventive step and capable of industrial usage. Now again, let's understand. invention means new. If I bring a product again which is already there in the market, already known, that cannot be an invention, right? An invention is something advancement that you have brought in a product. So let's say I have brought in a self-driving car. So it's an invention. One. Or a process, water purification process. The entire process is covered. Okay. So either a product or a process can be invented. That is the one condition. Then second is it should involve some kind of advancement or a inventive step. Now when I say inventive step means what? So that also has been defined here. Okay. What do you mean by the term inventive step is given under section 2JA? Invention is given under section 2J. First one, inventive step. Inventive step, according to you, what do you think? See, it's very easy to understand the words, but to explain it, define it becomes very difficult. So, according to me, inventive step means there must be some technical advancement. So, there must be some kind of advancement in technology, advancement in the existing knowledge than what was currently there. Second, advancement is there. Next, it should be of economic significance, having some kind of monetary, commercial use, industrial use, economic activity it should generate. And next, it should be non-obvious to the person skilled in the art. So a person of that field should not be able to catch, okay, he should find, oh wow, it's really an invention. When there were so many mobile phone manufacturers, when Apple launched the iPhone with touchscreen, it became an advancement even to the people who were skilled in that field. Okay, so there was from so many times, there was Google being used and everybody knew, there were software engineers, and moment OpenAI came, which launched the ChatGPT, it brought in a revolution. So this brings an advancement and it is not obvious to the persons of those fields also. So there is some real inventive step involved. Now, can you give me some examples of inventions? Okay, some kind of examples of inventions where you will realize, oh, okay, fine, this was something new that was brought into the industry. When Apple launched, obviously Apple is one of the highest number of patent holders in the world, one of the highest. There is IBM the highest, there is Samsung the number one, Samsung fridges, Samsung phones, Samsung tabs. Okay, Samsung is there in multiple other products as well. Okay, air conditions, etc. Similarly, Apple, when they brought the VR headsets, okay, it brought in a advancement into the field. So anyone who launched the VR headset where you get virtual reality was a advancement. He can get it invented and patented in his own name. The next, if you go to see the drone cameras, so when these drone cameras were something new, okay, it was an advancement to the time when before drones were introduced, there was nothing like that. Okay, so this became a very big advancement to the industry, and now drones are being used for military purposes, not only for marriages and commercial purposes, but even nowadays people are also owning drones just to get their own photographs and get them their own travel videos, etc., to just make those. So it brought in a big, it is capable of being manufactured industrial application. That is, it will be used in an industry, it will be manufactured, it is economical activity can be generated, profit can be earned, it is useful to the people. Then next, if you go to see some of this, I can say is the future, okay, which is ongoing inventions. Like Elon Musk, he had launched the Neuralink. It is a chip that goes into the brain where he will make humans superpowers, humans superhumans. Like he said that robots can be made into AI and intelligent. Imagine if humans, if they would implant this, and this is still ongoing. He wants to implant it in his child first. So with the implants, any kind of diseases can be cured. It could link, especially for those who are in vegetative state or have medical conditions, it can help them improve. So if that works, he can definitely get his patented in his name. But however, Elon Musk has already got a lot of invention is in his name already. If you know, Tesla cars, the electric cars or the self-driving cars are also got patented. And also not to forget, the future of transportation according to OpenAI and according to Elon Musk is Hyperloop. If you remember, the electro, or we could say the trains which go with the electromagnetic systems which run, okay, they call it as mech trains, etc. Okay, so these use your magnetic levitation to propel these particular rotors and motors and these particular cabins which move. So this, what Hyperloop is there, is going to be on solar energy. It's going to be cheaper, it's going to be faster. They're saying it's going to be it's going to run at the speed of a jet, and there are going to be people sitting inside. Okay, and this could be the future of transportation. So again, he has brought this entire concept of how solar energy, how magnetic levitation can be used to transport people at a faster and economical, cost effective manner. Then we see artificial intelligence, robots that are also being made. So anyone who's making these kind of inventions can get it in his name. Next, you also see there are 3D printers. There are a lot more invention. Anything you look around is an invention. Right from the laptop that you're holding, the phone that you're doing, the AC in which you're sitting, the cameras that are there in front of you, anything, just look around. Even in your computers, every part, motherboard, you have your hard disk. From hard disk we shift to SSD. All of this, the chips that are launched, everything is getting patented. So for patent, now very important question and a very important concept that you should know now. For a invention to be patented, there are three important things. For a invention to get registered, patented, and monopoly rights being given to the inventor, there are three criteria that need to be fulfilled. First, it should be novel, it should be new, it should be non-obvious even to the persons in the field, and next is it should be of industrial applicability. When I say industrial applicability, means what? I told you, it could be manufactured and sold, etc. Now in patents, the definition of patents, when we see section 2(1)(m), they give you a very basic definition. They say patent means a patent for any invention granted under the act. So patent means a patent granted under the act is called as a patent. So anything, if you got a certificate, that is a patent. An invention is considered as new or novel. Now if someone will ask you how you can say that it is new or no, okay, whether you should grant it or no. So logical sense, it should not be available in public domain. It should not have been anticipated by the persons of the field. From the existing knowledge, you can say obviously from this you can make this. It's very obvious. So that should not be there. From the prior publication, that all should not be there, whether it be in patent or non-patent literature. Patent literature means what? There are articles and publications made of patent journals also, not from there or from any other magazine. It should not have been published and obvious. Invention is considered as novel, new, if it is not been anticipated by prior use or prior public knowledge in or outside India. Next, Bishwan Prasad Radhe Shyam versus Hindustan Metal Industries. Now let's see what they have spoken. This I want you all to quote in the exam. You can proactively, it won't come in your exam, but you have to write it. Why? Because it tells you the object of the patent law. It tells you the object of the patent law. So you will write, whenever any question is there, you will write that the patent is an exclusive right, definition of patent you can write, and then you say that the object of the patent has been given in Vishwanath Prasad versus Hindustan Metal Industries. What is it according to you? I believe you will also be able to tell. What is the purpose of giving this monopoly right to a inventor? So again, it will encourage scientific research, new technology and industrial progress. If I am getting a monopoly right, I will be encouraged to invest in finding more inventions. So there will be more scientific advancement, there will be newer technology available, and their industries and will progress. Next, to get this monopoly right, you have to disclose your invention and the complete details. We will see that in the application you have to tell completely. Only then you will get protected. So to get this monopoly grant, the cost that you have to do is you have to give the full complete specification of the entire invention, how it was made, etc. Then only government will protect you. Now, patentee. You have understood what is an invention. Yes. What is an inventive step? We've understood. What is a patent? We've understood. Now, what is a patentee? The government is the grantor of patent. So they are the patenters, and the inventor is called as the patentee. Okay. The inventor is called as the patentee, or if I am getting granted the patent, I am the grantee. Okay. So or the proprietor of the patent. So as to mean the person that is in whose name it is going to be registered. Invention, we saw. Invention means it should be a new product or process involving an inventive step and capable of industrial application. We had done that. It was section 2(1)J. An inventive step was in 2(1)JA. Now, when we say capable of industrial application, means what? Common sense. It should be able to be produced and all those things which are there. That the invention is capable of being made and used in an industry is called a industrial application. Section 2(1)L, the term new invention. Now, when we say the term new invention, means an invention which has not been anticipated by any publication or used in the country or elsewhere in the world before the date of making the filing for patent. Simple. When I say new invention, means what is not priorly known by anybody. Okay, before filing the application, nobody knew it. Invention is something construed as a new and altogether new process having inventive step potential of industrial usage. So invention means something new that you have made, a product or process, and capable of industrial usage. So they are repeating it. The real purpose of patent system is to stimulating new innovative practice. To stimulate, once you give the rights, powers, benefits to inventors, it will stimulate, encourage, boost more innovative practices and technological advancement, leading to greater public interest. Now, in Raj Prakash versus Mangat Ram Chaudhary, held that inventive creation is notable to discover something or find something not already found or by anybody previously. Common sense. They are teaching us what do you mean by new. New means which is not found by anyone else previously, is called as a creation. The fundamental thing is that the creator was the first to embrace it. The main issue in this case was the basic creation is, now in this very simple, don't have to get into the heavy words, very simple. The main issue in this matter that each basic creation is asserted in the form of a novelty, and you will have to see the specifications keeping that. So before granting the patents, we have to see that did the creator first embrace it? Did the creator first asserted it that this is my creation? if he has done, and we will see the what all efforts he has done. For example, I say this is my book. So they will go into the specification. When show me where are the earlier publications, show me a laptop, show me when was the first efforts done. So all of that investigation will be done if there is a dispute. Whoever is ascertaining it first, along with all his proofs, will be entitled to the patent. Simple logical things. Now, after understanding the patents that it is given for inventions who have done inventive step and they get a monopoly right, what is the advantage of patent law? So very important, they can ask you, what is the advantages of patent law? Very, very simple. If I get a patent, I get a right to restrict others, restrict outsiders from using it without my consent. If they do, then what you'll do? If others have started using your invention, if Apple was really angry and really upset and really face a lot of losses because China does something called as creative re-engineering, where they engineered products, they break it down and try to find out newer techniques. So Apple wants to get and enforce the worldwide patents more strongly. So if someone has tried to use your creation, okay, or invention, then you can file a suit of infringement. Infringement means someone has encroached it, someone has misused, unauthorized use of your invention is called as infringement. You can file cases and get remedies such as compensation, injunction is to stop the person from using. Next, I can also assign the patent. Wait, what? What do you mean by assignment of patents? Very simple. So first is, if I have created something, invented something, and let's say I have put it in my name, I've got the patent granted. Once the patent is granted, then I will realize that, listen, I manufacture, I sell, rather I want to assign it to someone. I want the rights to be to a big, huge company. I will go and sell my rights. So patentee can, that is me, the inventor, can commercially exploit himself, or he can pitch his creation to any skilled individual. So he can tell anyone else that, listen, I have made this, do you want it in your name? You take it, I am assigning it. Or I can even sell it to you, or I can give it for you a short time for using it, and permit him to abuse his item. Mean, you do what you want, take it, just give me so much money. So the creator can also get this benefit. The holder of exclusive permit can also avail the rights. Now again, to whom you have assigned it is the holder of rights, can also avail the benefits if third party is using. For example, if the inventor has sold off his rights or assigned his rights to another person, okay, to this person, Mr. A. If there is another person called as Mr. B who's doing unauthorized use, who can file a case? Inventor will file, Mr. A will file, or any of them can file. So the obvious answer is inventor can also file, and the holder of the exclusive right can also avail the rights given to the patentee and file cases and bring a suit in his own name because he is obviously paid for it. The next is a patentee gets the privilege to make changes or alterations and you can get a patent of addition in your name. Means what? If I have made iPhone, okay, now I will launch a new version with some kind of additions or some kind of modifications, and I will register this also as a patent of addition, and even this will get the protection. So again, in my invention I can bring in further betterments also, so that also is allowed. So this also the creator has been given that he can make changes in his invention, etc. So again, concluding the basic concepts, what can be patented? So this can be asked in the exam, a direct question. So the answer is, what can be patented? A invention can be patented. Okay, it should be either a product or a process. So products, obviously we saw VR headsets, a car, mobile phone, a particular anything, a ring light can be patented. For nowadays for Instagram and all of this, they make these kind of vlogging cameras, vlogging kits can also be patented in the name. Or a process like a water purification process, or a sewage industrial treatment process, on how do you treat the industrial process, the entire anything can be there. Or an engine, how does the engine pump, the entire process of electric engine working can also be patented, provided it is new, involves an inventive step and capable of industrial applications. However, now we're coming to two important sections. All this can be patented, but you can't patent something which is given in section 3 and 4. Very, very, very important. Very, very important. What is this? That, and this is asked multiple times. The most frequently asked question from this chapter is section 3 and 4. What questions do they ask? They say that what are not inventions? What cannot be patented? However, it must not fall into the categories of invention that are not patented. So direct exam questions, it comes that what inventions cannot be patented. So section 3 and 4 has been given. What does 3 say? Okay, this is most important. So let's see, the logical sense is there. What inventions will not be granted patent rights? If it is against public policy, if it is frivolous, fake, if it is, let's go step by step. If an invention is frivolous, okay, frivolous means fake, claims anything obviously contrary to the laws, it's a fake thing, it's something mischievous, will not be registered. An invention which is the primary or the intended use or commercial exploitation which could be contrary to public order or morality. So let's say if there is some product that is being made which is against public policy. For example, you make a electric chair, death chair, a chair, you sit on it, you get electric shocks and the person dies. It seems very, very immoral, will not be there. Okay, if certain kinds of toys have been banned, okay, from being sold, said to be immoral. Then mere discovery of a scientific principle. Now understand the word discovery. If I am discovering something, there is a difference between discovery and invention. I want you to tell me whether there is a difference between a discovery and an invention. Yes or no? Obviously yes. A discovery is found where an invention is made. So discovery is found whereas invention is created. So obviously if a moment they give you that there is a discovery of something, I have discovered a place, I have discovered a scientific principle. So that is not a invention, because discovery means that it is already there. If I find tomorrow that there is one more element in the world, so it cannot be patented. It's just a knowledge gap that has been filled up. Okay, of a scientific principle or a discovery of any living thing or a non-living substance. For example, I find a new living thing below the surface of the earth in the waters. It won't get, you have discovered it, but you won't get it patented because it's not an invention that you have done. Next is mere discovery of a new form or of a known substance which does not result in enhancement of the known efficiency. Efficacy means efficiency of that substance, or a mere discovery of any property of any process, apparatus, etc. So again, they given the word mere only they give you means finding, merely finding a new substance, okay, which does not result in any enhancement of any efficiency in anything or any property cannot be done. Similarly, as it was given above. Next, a mere admixture of certain things. Admixture means what? If imagine I'm taking a few products, I'm mixing it well, and I say it's an invention. So that would not be there. A bhel puri cannot be called as an invention. Okay, because why? It's just a mere admixture. If I take two substances, synthetic rubber and natural rubber, and mix it up and say that it is an invention without any increasing the efficiency in the product or in the use, it cannot be called as an invention. In invention, we mean it's some new product that has come which had an immense amount of mental exercise, a kind of research that has been done, which is capable of being manufactured, sold at large scale, etc., is what we are talking about. The mere arrangement, even like let's take an example. If I'm making a artificial pacemaker, which if for people with heart ailments, diseases, there is something called as a pacemaker. You put it up and it helps the heartbeat. So that is really bringing in a kind of a thing, or a ECG machine, etc. So a mere arrangement or rearrangement of things or devices is not called as an invention. A method of agriculture or horticulture. So how do you do agriculture? Horticulture is not covered. Any process for medical, surgical processes, other treatments of human being cannot be done. So imagine I do a method of doing a plastic surgery or treatment of a certain things cannot be patented. Plants and animals in whole or any of part thereof other than microorganisms. So again, you cannot patent a plant in your name. You've not created plants and animals, right? So that cannot be done. Okay. However, nowadays you have certain kind of mixtures which are there, which bring in. So those microorganisms you can be, the benefit of this can be given. A mathematical or business method. How do you do business? What is your method of doing business style? Or a mathematical formula, etc. Or a computer program. These computer programs are copyrighted, not patented. Again, literally dramatic, artistic creations are copyrighted, not patented. A mere scheme or a rule or a mental act or a method of playing a game. Vishwanathan Anand or Prague or Magnus, they are all chess experts. They're explaining how chess plays, what are the chess moves. So these can't be patented. A mere presentation of information, a beautiful PPT, like the entire slides that I have made has involved a lot of hours. I want to patent it. It cannot be patented, right? So these are not something which goes into industrializations, etc. You can copyright a book. Topography of integrated circuits. Now integrated circuits, again you go to see is your circuits within your laptops and your computers. Topography is the placement of things, how you have arranged the things, that cannot be patented. These are all designs, can go in Designs Act, etc., but not patents. An invention, so the topography cannot be patented. Topography is the placement of things, the visual aspect of placing things. An invention, which in effect is traditional knowledge and an aggregation or duplication of those known properties. Something which is known cannot be done. Now we have done with section 3. Section 3 and 4 cannot be, these inventions cannot be patented. Section 4 talks about atomic energy inventions. Clearly section 4 prohibits the grant of patents for inventions relating to atomic energy. Clear? Section 4 says anything with respect to atomic energy cannot be patented. Now coming to section 3, can you tell me few points from your, it's a very common question. So let's see. First we can see computer programs, method of playing a game. Then next, if you go to see your anything which is related to copyright, literally artistic work cannot be done. What are the other things? Anything which is immoral. Next, what is the other thing? which cannot be patented. Can mere discovery of animal, thing, person cannot be done. Okay, then I told you about bhel puri, that is what, admixture. A mere arrangement or a rearrangement of things cannot be patented. So these kind of inventions cannot be patented. And section 4 simply says anything related to atomic energy cannot be patented. So what is the criteria for patentability? Again, it should be novel, that is new. It should be non-obvious, that it is shouldn't be known obvious for a person who is a expert in the field. Capable of industrial application and should not attract section 3 and 4. Now there was a very simple case law and very interesting case law as well. What did they say in Novartis AG versus Union of India? This the main part is important. What did they say? That for medicines and medical things, when patent was being given, okay, in certain cases in pharmaceutical inventions, what was happening is just by bringing some chemical changes, again a person was again coming and trying to patent the similar thing. So then they said, listen, just by changing the chemical components or just by changing some minor things cannot be said that you will get a new patent. For a new patent, it has to be some innovative, inventive step further ahead. Second, with respect to pharmaceutical, that mere changing the property or saying that the property is going to be more durable, that is not going to be decided. When patent will be given in case of pharmaceutical, when you find that the efficiency has improved drastically, that we will say that there is a big leap, there is a big invention, we will grant it. So this was done to prevent repetitive patenting and unjust extension of the patent. The court emphasized that for medicines, the therapeutic or healing efficiency is crucial. So for medicines, what we will see that whether the effectiveness has increased, merely showing the improved chemical properties is not sufficient, that it is more durable or it has a better flow, better stability, these are irrelevant. What is important is what he must prove that there is an increase, what he must prove that there is a increase in the therapeutic efficiency. Then we are seeing the persons entitled to make an application. So persons entitled to make an application. Which persons are entitled to make an application for patent? Think and tell me. Forget about section 6. Okay, don't read it. So very simple. The owner will come. So owner can be called as the true and the first inventor of the product. If the owner dies, his legal representative can come. Or if the owner has sold off his rights, he's sold off, okay, then, or he has assigned it to someone, then even that assignee can come to make some applications in patent, or if it has been assigned means either to sell it completely or to give it for limited period of time. So assignee can also come, so, and his legal representative. So owner can come, or the owner's legal representatives can come, assignee or assignee's legal representative can come. Okay, the application may be made by him alone or jointly with some other person as well. So the term assignee includes the legal representative as well, as we saw. Now the form of application and provisional and complete specification we will do tomorrow. Clear? Owner of innovation made. Yes. Yeah. So Yash, thank you so much. Hari Krishnan, great. And Lakshmi, great. Okay. So that is it for today. Tomorrow I will cover the balance part of the chapter. Clear? So that is it for today, and the balance part we'll cover tomorrow. Around the same time I will post it up. Okay, so we'll continue with this chapter and we'll cover. That's it. Thank you.